Hello, my name is Jesse Burbank, and I'm a member of the Dole Institute Student Advisory Board. Welcome to the Dole Institute of Politics, and thank you for attending tonight's presentation. The Dole Student Advisory Board is composed of KU students committed to the work of the Dole Institute. We attend regular meetings, assist in events like this one, and plan an SAB-sponsored program every semester. Members of the SAB receive great opportunities to network with our special guests. If you are a student and would like to join, please contact the Dole Institute. The Dole Institute would like to hear from you. If you enjoyed tonight's program, please let us know by contacting us on Facebook, Twitter, or through our website email. Your attendance and feedback help shape future programming. Before we begin tonight, I'd like to remind you to please turn off your cell phones. And now, please welcome the Director of the Dole Institute, Mr. Bill Lacey.
Thank you, Jesse. Thank you very much for coming out tonight. Let me very briefly tell you about three announcements. One, we're having our Constitution Day program next Tuesday night at 7:30. It will be on campaign finance. We'll be looking at Citizens United and other very important issues. You won't want to miss it, so join us next week. We have our 10th anniversary and first ever Fellows Reunion coming up next week. It'll be Thursday and Friday. You can look on the back of your program. It'll list the sessions. We're having 24 former fellows return to the Dole Institute. So it's really going to be very special. We started the program in spring of '05. It's going to be going on into the future. And this is going to be a fun program. So look at those discussions. Join us if you can. They'll be Thursday afternoon and Friday morning. And each of the former fellows will be participating. We'll have a discussion on what's going on in Washington, kind of the gridlock that we have in Washington. We'll have a discussion about civility and courtesy in politics, the importance of public service, and we'll have a discussion about the future of the two parties. So that should be very interesting. And third and finally, stay tuned. Tomorrow morning we'll be announcing the winner of the 10th anniversary Dole Leadership Prize for 2013, and it is a blockbuster. So look in your email, look in the news outlets tomorrow morning, and see who has been selected for that prize. Tonight we feature our third edition of our program, Neutral Ground. The idea is that when we have this 24/7 talking heads on TV and everybody's yelling and screaming at each other and interrupting people and trying to come up with the most clever soundbite, we actually provide an intellectual alternative with rational arguments on both sides of a controversial issue. That's kind of a little bit different approach, I guess, than is normally taken. But we become neutral ground. That's where the name came from. Neutral ground where people with different points of view can come to civilly discuss controversial issues. Now, we normally have audience participation in all of our programs. It's a little bit more limited tonight because we allow time for both of our advocates to present their cases and cross-examine the other side. But if you want to ask a question, if you will write it on the index cards that are available, and we'll have students, I think, have been passing those out, and if you think you might want one, you can always raise your hand and students will look for you and bring you one at some point. We'll collect those right before the closing statements, and then we'll select 2 or 3 questions for each side. We only have about 10 or 12 minutes for that tonight. I want to recognize 3 of our students who are playing a critical role tonight. Our timekeepers, Mitchell DePriest and Amanda Gress. Stand up, guys. Get a little bit of applause. And Eric Pauls, Eric in the back, who helped us recruit some of our expert witnesses. Tonight's proposition is this: resolve the death penalty should be abolished. Our advocates tonight are Pedro Irigonegaray for the proposition and Ed Duckers, who will oppose it. Each advocate will present their expert witnesses. Now for opening statements, Mr. Irigonegaray.
Mr. Lacey, Capital, that sounded pretty well, didn't it? Capital punishment is the state's premeditated and cold-blooded killing of a human being in justice's name. The state's primary justification for the death penalty is deterrence, the suggestion that the killing will deter others from similar conduct. Tonight, I will provide you evidence to establish that the state's reliance on deterrence as justification for killing is based on myth and not science. In 2012, the National Research Council of the National Academies, an organization composed of distinguished scholars, advisors to our nation on science, engineering, medicine, through its Committee on Deterrence and the Death Penalty and the Committee on Law and Justice, reached the striking and convincing conclusion that the research about deterrence and the death penalty done in the past generation should be ignored. The committee found that the research is not informative about capital punishment. Nothing is known about how potential murderers actually perceive the risk of punishment, said Professor Daniel Nagin, the committee's chairman. Dr. Nagin will be here tonight to present the findings of the committee. His more than 30 years of experience in deterrence research and extensive knowledge relating to the death penalty will establish facts, not just ideas or suggestions. Since 1972, 142 people sentenced to death have been exonerated. That's close to 2% of all sentences. The reasons include prosecutorial misconduct, incompetence of counsel, withheld evidence, and a variety of other errors. The risk of killing the innocent is a significant concern. Facts suggest that innocent people have been put to death. Minorities and the poor are at greater risk. The cost of the death penalty also greatly exceeds the cost of life imprisonment without parole. Savings to the state could be better applied to reduce taxes, perhaps hire more law enforcement and investigators with which to really put a dent on crime. The Kansas Crime Victims Compensation Board was limited in 2012 to a total of $3,000 for compensation of murder victims and less than $2,700 for those victims of domestic violence. Kansans' safety is protected by sentencing those convicted of murder to life imprisonment without parole. The abolition of the death penalty is not a liberal or a conservative issue. It is an issue to be determined on the facts. The facts that you will hear tonight are compelling. They are persuasive for the proposition that the death penalty is in an inappropriate, outdated, and an unscientific way to deal with serious criminal behavior. Kansans deserve better. The world deserves better. The death penalty must be abolished. Thank you.
Mr. Duckers. No applause, please. You can applause at the end for everyone. Thank you.
Or you can applaud for me. Director Lacey, my good friend Mr. Irigonegaray, ladies and gentlemen of the audience. In June of 2001 at Terre Haute, Indiana, the federal government executed a mass murderer, a man who used bombs to kill over 168 people. This execution, like most executions, was accompanied by the normal hand-wringing and protests and silent vigils of those who oppose imposition of the death penalty. Almost exactly a decade later, in May of 2011, the federal government executed another mass murderer. And despite the fact that this execution was carried out without a trial and without any sort of due process, there was not a single word of protest. Indeed, the young liberal arts students that one normally sees at death penalty vigils protesting the death penalty were on this occasion seen dancing in the streets and partying on Pennsylvania Avenue in Washington, D.C. So why do I draw your attention to Timothy McVeigh and Osama bin Laden? I draw your attention to those two executions to illustrate the point that there comes a point where crimes are so heinous and so wrong and such a violation of humanity and mankind that no one is opposed to the death penalty. Whether it is Osama bin Laden or the Nuremberg war criminals who were hanged at the end of World War II, or Adolf Hitler if he had survived, for some crimes there is only one appropriate punishment, and that punishment is death, and no one disagrees with that proposition. With respect to deterrence, the reason we have a death penalty is largely to protect all of you, because the evidence in this trial is going to show that, in fact, the death penalty is a deterrent, and the person who signs the bill abolishing it is sentencing innocent men and women to death. Since Professor Ehrlich's seminal study in 1975, there have been at least 28 different academic studies in peer-reviewed journals that have concluded there is a substantial deterrent effect to the death penalty. And we will discuss those tonight. The evidence you will hear from the proponents of this are not that death penalty is not a deterrent. No, they simply criticize the studies and say you can't draw any conclusion. But they've not done their own study. And they didn't do their own study because, as I'll show, they're funded by the liberal Heinz Foundation that funds liberal anti-death penalty causes, and they reached the result they wanted to reach. We are not going to stay in the realm of academia with our case. You will hear tonight from two people who have hands-on, real-life experience dealing with the death penalty. First, you're going to hear from Nola Folston, who was the district attorney in Sedgwick County for almost 24 years. And she is going to tell you how the death penalty is administered, the sorts of crimes it is applied to, the fact that it is a deterrent, and she has seen that deterrent effect with her own eyes. She's going to rebut claims that it is too costly, and she is going to be able to rebut those claims that innocent people have been convicted and sentenced to death. You are also going to hear from Justice James Ardies, recently retired presiding judge of the Fifth Circuit Court of Appeals, or the Fifth District Court of Appeals in the state of California, who has worked with the death penalty as both a prosecutor, as a sitting trial judge trying cases, and as an appellate judge reviewing them. And he is going to speak to you of his experience with respect to the fact that the death penalty is a deterrent and serves other important social functions, including retribution for those crimes that are simply unforgivable. We'll give you specific examples of deterrence. We'll give you specific examples of why the suggestion that life imprisonment without parole is a solution is a lie. There is no such thing. People get paroled, political moods change, and it is not an accurate statement to say that the alternative is life without parole. And at the end of the evidence this evening, ladies and gentlemen, I'm going to be back to ask that you side with our side of the proposition. Thank you.
Okay, thank you very much. Now we'll take time for the affirmative case.
I will call Professor Daniel Nagin. Sir, would you please state your would you please state your name and occupation?
My name is Daniel Nagan, and I'm a professor at Carnegie Mellon University in Pittsburgh, Pennsylvania.
And what is your title, sir?
My title is Teresa and H. John Hines III, University Professor of Public Policy and Statistics.
Does the Hines family dictate to you precisely what research you may or may not conduct?
No.
Please state your educational and professional history.
I actually received all of my education at Carnegie Mellon University. I got my undergraduate degree there, as well as my PhD there in 1976. My first job, university job, was at Duke University. I then began working for the then governor of Pennsylvania, Dick Thornburgh, who subsequently became Attorney General in the Reagan administration. And then following my working with Dick Thornburgh, I returned to CMU in 1986 and have been there ever since.
Professor Nagan, do you have particular expertise on issues relating to the death penalty?
Yes. Deterrence, the subject of deterrence, was the subject of my PhD dissertation, and I've been studying the crime prevention effects of criminal sanctions ever since.
Are you familiar with the National Academy of Science?
Yes, I am.
Have you had any experience in working with the National Academy of Science?
Yes, I've had extensive experience in working with them. I'm a member of the Committee of Law and Justice and have been on 4 of their expert committees. I, in particular, chaired the committee that you mentioned, the Committee on Deterrence and the Death Penalty, which released its report in 2012, and also 30 years prior to that, I chaired another committee. I was the chief staff person for another committee, which also looked at what was known about the deterrent effect of the death penalty.
Regarding the committee that you chaired that addressed the death penalty, who were your co-members of that committee?
Well, there were a very distinguished group of scholars. Beside myself, who I chaired, there was Kerwin Charles, who's an economist at the University of Chicago, Philip Cook, who's an economist at Duke University, Stephen Durloff, another economist at the University of Wisconsin, Amelia Haviland, who's a statistician and a colleague of mine at Carnegie Mellon, Gerald Lynch, who's on the U.S. Court of Appeals for the 2nd District, Chuck Mansky, another economist at Northwestern, and then a person who's personally very special to me, James Q. Wilson. He's one of my intellectual heroes. Jim was one of I would call the founders of what's not come to be called the neoconservative movement. Regrettably, Jim died just shortly before our report was released, and the report was dedicated to him with the inscription as a quote of Jim's, "I've tried to follow the facts wherever they land." And this was something that guided the work of the entire committee. And of course, Jim, through the committee, that we tried to follow the facts wherever they landed.
What was the mission of the committee?
The mission of the committee was to assess what is known about the deterrent effect of the death penalty. To put that in context, Ed did mention that over the last 30 years, there's been a number of studies that have concluded that there's a death penalty, a deterrent effect of the death penalty, but there are still an equal number of studies that concluded that there was no deterrent effect. And then finally, there were even a smaller number of studies that argued that the death penalty actually exacerbated the homicide rate. And we were asked to assess the scientific validity of that evidence.
Would it be fair to say that that was the first time that a global review of all the studies were conducted?
Well, it was a follow-up review to one that had been, I mentioned earlier, 30 years prior, in which the evidence had been the evidence on the deterrent effect of death penalty had also been assessed. I should point out that James Q. Wilson was also a member of that committee as well, and in fact, that committee concluded, including the study by Isaac Ehrlich that Ed mentioned, concluded that those studies were so flawed that they were not informative about the deterrent effect of the death penalty. Our conclusion about the evidence that had accumulated since 1976 was similar. We reached a similarly negative conclusion about the scientific validity of that evidence. We concluded that it suffered from such grave flaws that it shed no light on this question, and we went on to urge that therefore that evidence should not be appealed to in making policy decisions about the death penalty.
Do you have an opinion, Dr. Nagin, regarding the death penalty as it relates to cost?
Well, cost was not one of the issues that we specifically examined as part of our committee, but we did. But as part of our deliberations, we did learn it, but we did consider. That was part of our. That wound up being an element of our deliberations, and many dozens of states. There have been studies of this in many states, and they consistently conclude that the administration of the death penalty is far more expensive than the administration of non-capital punishment crime.
And are there alternatives that those savings could be employed?
Well, in my view, yes. I recently completed an essay called "Imprisonment and Crime Can Both Be Reduced," and in that essay, I argued, along with my co-author Stephen Durloff, that while there was very little evidence of the crime control effectiveness of very lengthy and severe criminal sanctions, there was ample evidence that police, if they were properly deployed, could be very effective in reducing crime. And we argued that the resources that are being now used for the purposes of administering very severe penalties should be transferred to the police.
Are you familiar with the issues of errors in death penalty cases?
Again, that was not a central issue in our deliberations, but it wasn't. We inevitably had to deal with that. And as you indicated, since 1972, there have been 142 exonerations. That's equal to about 2% of all death sentences that have been passed down. And furthermore, 36% of death sentences or the convictions thereof have been overturned for various legal kinds of problems.
Dr. Nagin, there are some prosecutors that suggest that in order to be more effective in obtaining a plea agreement, once an individual has been charged with murder, that the death penalty is a required tool for their ability to obtain a plea. Was that a consideration discussed in the committees?
It was an issue that was discussed in passing in the committee, but it's an argument that I don't quite understand. My understanding of the purpose of the criminal justice system is to, first of all, to act as an agent for preventing crime and delivering justice in as efficient a fashion as possible, efficient a manner as possible. And as I indicated, there's no evidence that the death penalty is, and this is an important point, that the death penalty is an incremental deterrent to punishments like life imprisonment without parole. And indeed, one of our key criticisms of the research that has been done to date on the death penalty, there is no study which answers the question of whether there is this incremental deterrent effect, because no study ever took account of the alternative sanctions, like life without parole, that were available to states to punish that crime. So one is is that there's not an evidence of a deterrent effect. The second is that on the efficiency grounds, as I indicated, there are many studies, including a study here in Kansas, showing that it is not expensive, less expensive to have the death penalty. And the third part, having to do with delivery of justice, is that I would think that if the prosecution has a case which is sufficiently strong to convict the person based on the evidence they've accumulated, why then do they need the leverage of the death penalty to try to incentivize a person to plead guilty?
Sir, you heard comments that the argument that we present is based on liberal extremism. Would you comment on that issue, particularly as it relates to the work that was done by the National Academy of Science?
Well, in our work, as getting back to Jim Wilson's comment that he tried to follow the facts where they lay. He was an important, even though he was ill, he was a very, very important figure in our deliberations. And I will say, in our deliberations, we never discussed our personal views about the death penalty. We just simply discussed what the scientific validity of the evidence was. And we came to the conclusion that all of these studies, regardless of their conclusions, had no scientific basis to them. And we raised three important criticisms of that work. One, I already alluded to. The practical question is the deterrent effect is capital punishment a deterrent effect above and beyond a penalty like life imprisonment or life without parole? And none of the studies were designed to answer that question. They didn't even include data about the alternative penalties to the death penalty. A second key point was that these studies, as I pointed out, these studies came to radically different conclusions based on how they measured the risk of execution. Some ways of measuring the risk of execution showed results which were suggestive of deterrent effect. Other ways of measuring this risk found no effect, and as I said, still others indicated that it actually exacerbated the problem. When we looked at these risk measures, we concluded that they bore no relationship, no credible relationship to what that risk was. And then we further pointed out that even if somehow they could, there was actually no scientific basis for knowing how potential murderers may perceive that risk. And that finally, we concluded that the studies were based on evidence, on statistical models that just made assumptions that were simply not credible. And so getting back to your point about this, there was no political bias whatsoever in the committee. It was not even an issue that we discussed, and we made it clear in the committee that that was not something that we were, in our report, that was relevant to us. We were simply driven by the following idea that public policy is not well served by masquerading pseudoscience as science, and that all of these studies were pseudoscience and so flawed that they provided policymakers with no good information about the effectiveness of the death penalty as a deterrent.
Would it be then fair to say that until data is developed that can establish definitively that deterrence is obtained vis-a-vis the use of the death penalty, politicians should not rely on previous studies to use deterrence as a reason for supporting capital punishment?
Well, is that we concluded that these studies were so flawed that they had no evidentiary value, none. Now, in our report, we made recommendations for the kinds of things that needed to be done so that it was possible to do research which might provide useful information on this question. Maybe not definitive, but at least useful information. And among the things that was necessary to be able to do that was we needed to have good data, not only on the frequency of use of the death penalty, but the frequency of use of alternative methods for punishing homicide, which is important to keep in mind that most people who commit murder are not punished with a capital sentence, but they're punished with some alternative form of incarceration, usually life without parole or life imprisonment. And we need to have data on the frequency with which those punishments are being used to come up with scientifically valid evidence on what the incremental deterrent effect of the death penalty is.
Thank you very much, sir. I have no further questions.
Okay, now time, Mr. Duckers, for your cross-examination. You'll have 9 minutes.
Thank you, Mr. Lacey. I want to make sure I understand your testimony, Professor Nagin. You are not saying that the death penalty is not a deterrent. Rather, you are saying that based on the work of your committee, there simply is no evidence that it is a deterrent, correct?
Our conclusion was that...
Could you answer the question?
I'm telling you, I'm answering the question, is our conclusion was that there is no scientific evidence on this question. People may have opinions about this, but there's no scientific basis for those opinions.
Okay. And there's no scientific basis that it's not a deterrent?
Correct.
And okay, so to answer my question, you're not saying that it is not a deterrent. It may well be. You just don't know based on the current academic research. Fair statement?
Nobody knows.
Okay. Now, you are the Hines Professor of Statistics at Carnegie Mellon, correct?
Teresa and H. John Hines, the third professor.
And you know how to use statistics and econometrics to build models to solve propositions, correct?
Yes.
And in fact, in the paper that you did in 2010 with Professor Durloff, I believe, you use those sorts of statistical and econometric measures to build mathematical formulas to establish the proposition you testified to regarding the benefits of enhanced police over enhanced sanctions, correct?
Correct. It was actually, we didn't do original statistical modeling. We reviewed the evidence on these issues.
But you know how to do it. You know how to build a model.
Yes.
Did you, after identifying all the flaws in the academic research that's been done for the last 35 years, as a professor of statistics, did you sit down and correct those flaws and build a model to answer the question?
I'm sorry, I don't understand your question.
After deciding that all of the academic work that had been done by your predecessors for 35 years was flawed, did you sit down and build a model to answer the question yourself?
You're referring to the death penalty research?
Yes.
The report lays out a research agenda that needs to be followed for not only me, but anybody to do credible research on this question. And I mentioned one of them. One of them was collecting adequate data on not only capital sanctions, but non-capital sanctions. And another part of our research recommendation was that we needed to better understand how potential murderers might perceive this risk of execution.
And so, to answer my question, it would be fair to say you have not constructed a model yourself based on all this work you've done as of this point to determine whether the death penalty is a deterrent. You've not done that work, right?
We said that it's not possible to do that work without the data and research that we suggested in our report.
Okay.
For me or anybody else to do it.
Your committee did not do that as a part of your work.
Did not do that research?
Yes.
No.
All right. Now, your committee actually did work for something called the National Research Council, correct?
Was part of the National Research Council, yes.
And the National Research Council was financed by the Tides Foundation and the Proteus Foundation, correct?
And the National Institute of Justice.
Yeah. And the Tides Foundation is financed by the John and Teresa Hines Foundation that funds your academic chair, correct?
I am unaware of that.
Do you know how many millions of dollars those two organizations have given to anti-death penalty efforts in just the last 2 years?
No.
Were you aware that the financing for your study from Proteus just over the last 2 years totaled $10 million to anti-death penalty efforts?
The funding sources for these studies, I know nothing about them. The funding sources for these studies had no effect whatsoever on our deliberations.
Well, do you think that the Tides Foundation puts out monogram after monogram against the death penalty? Do you think that they wanted to fund something that was going to reach a conclusion that they disagreed with?
You'd have to ask them for their motivations.
Okay. Now, I think we all know the answer to that. What studies found there was no deterrent effect? And what academic journals were they, peer-reviewed academic journals were they published in?
There were, there were a number of studies that reached that effect that were appeared in the American Sociological Review. There was a series of studies that was done by an economist, Justin Wolfers, and an economist, Justin Wolfers, and an economist, lawyer, John Donahue, which appeared in the American Economic Law and Review.
Now, were the results of your committee, you published them in a book, correct?
It was published by the National Academy of Sciences.
Okay. Was it published in any sort of peer-reviewed academic journal?
Yes. It was all reports of the National Academy of Sciences go through very rigorous peer reviews. We had a dozen academic reviews of this report before it could be released.
Okay. And the studies that you were critiquing were also peer-reviewed, correct?
Some were and some were not.
Well, did you look at Professor Erloch's seminal study from 1975 that was published in the American Economic Review as a part of your work?
Well,
it's just a yes or no. Did you look at that study?
That study was reviewed in the prior report, which concluded that it was groundless. Its conclusions were groundless.
All right, and those conclusions were commented on by Gary Becker, correct? And Richard Posner and George Stigler?
You'll have to tell me what their comments were.
Well, it's what it says in you read the report, didn't you? It says it right there at the bottom of the report that George Becker, Posner, Nobel laureate George Stigler all commented on Professor Erloch's study.
I'm not sure what reference you're referring to.
Now, you used Professor Becker's economic model of crime in the study that you did with Professor Dunfeld, correct?
Durloff, yes.
Durnoff. And what Professor Becker says, as I understand it, is he basically sets up an economic model and says that criminals engage in rational decision-making, and they look at the utility of committing a crime versus the risk of being caught and process it that way, correct?
Yes.
And so, according at least to Professor Becker, criminals are cognizant of the consequences of their actions when they make their decisions, correct?
Yes.
And are you saying that while they're cognizant of the consequences of their action, they're oblivious to the fact that they could be put to death if they commit certain crimes?
Gary Becker's theory is just that. It's a theory, and all theories must be put to an empirical test. And there are aspects of the predictions of Becker's theory which have been validated, particularly with regard to the probability of the chances of being apprehended. Those were the results that Steve Durloff and I emphasized in our review. And there are other aspects of it that have yet to be validated.
But the basic aspect, that criminals are cognizant of the risk of being caught and the punishment they'll receive, is in fact the formula that you and Professor Durloff used in the paper that you published on May 7th, 2010, correct?
I'll repeat myself, is that we reviewed the evidence on what we know about the deterrent effect of penalties and concluded that there was large amounts of evidence pointing to the effectiveness of apprehension risk in deterring crime, and that the evidence on the effectiveness of severe penalties in deterring crime was much more limited.
I'm almost out of time. One last question, Professor. As you know well from the work you've done, scores of academics over the last 35 years have published peer-reviewed studies concluding that there is a deterrent effect.
Excuse me, he is out of time.
Can I just finish this last question?
No, we'll have to conclude there. I'm sorry, Mr.
Okay.
Duckers. Okay, thank you, Professor. Mr. Duckers, you get an opportunity to present your case now.
I'd like to call Nola Folston.
Good evening. Good evening.
Good evening.
The hot seat.
Good evening, Ms. Folston.
Hello.
Could you please briefly, because we don't have much time, tell the audience what your educational and professional background is?
Born and raised in New York. Came to Kansas, went to Fort Hays State University, graduated from there in 1972, attended the University of Kansas, was a member of the Civil Rights Commission for the state of Kansas as an investigator. It urged me on to law school. I graduated from Washburn University School of Law with my Juris Doctorate degree in 1976. I became a prosecutor in 1977. In 1981, I was a corporate litigator. In 1989, I was elected as the district attorney for the 18th Judicial District of Kansas, a position I held until I retired this past January after 24 years.
In that position as the district attorney, did you have occasion to deal with issues related to the death penalty?
Absolutely.
As a result of that work, have you been able to form an opinion as to whether the death penalty should be abolished?
Many opinions.
What are your opinions as to whether or not the death penalty should be abolished?
I believe that the death penalty is an effective means of punishment for the most outrageous, egregious crimes committed by individuals who are cognizant of the consequences of their crimes, capital murder being a first-degree murder with special circumstances. In that regard, as the district attorney, over the number of years since 1994, when the death penalty was reinstated in Kansas, the jurisdiction of Sedgwick County prosecuted about 15 cases. Not all of those went to trial. We had a higher conviction rate, but a lower number of cases that were prosecuted out of our office. We did not ever use the death penalty as a conduit to accept a plea. We believed it to be unethical and inappropriate. If an individual was responsible and beyond a reasonable doubt, there were circumstances that led us to believe a death penalty should be placed. We did so only with careful review and consideration of all of the evidence, and did not make an automatic statement to the public regarding the position that we were taking until all of the evidence was in, until our defense counsel was able to come in and discuss with us the position of their client. So it was not used in Sedgwick County as a method of management of cases. It was strictly on a criminal justice basis, constitutionally measured, and effectively and ethically carried forward.
As a prosecutor in the first instance, is the decision to even seek the death penalty one that fell to you?
As the district attorney, I'm the one that was responsible for following and assuring that the laws of the state of Kansas were carried out. Whether I liked a law or did not like a law, my option was only to follow the law, and that was the responsibility of the office that I held.
And how would you decide whether or not the death penalty should be sought in a specific case?
When any homicide occurred in the city of Wichita, for the period of almost 24 years as the elected official, I attended most homicides that ever occurred in that city, day or night. I was at the scene, I observed the information, I was involved with listening to the witnesses. I, along with the presentations of the law enforcement agents and other individuals in the criminal justice system, reviewed the case, and the decision was left to me as to whether or not the case qualified. And upon it meeting the qualifications, then and only then would we charge a capital case. The seeking of the death penalty was a separate issue because you can file a capital case and not ask for the death penalty. And that happened in a number of cases as well.
Okay. There was some testimony about the cost of administering the death penalty. Do you have an opinion as to whether it is more costly to pursue a death penalty case?
You know, I really do have an opinion about that. I was stunned a number of years ago, and I actually wrote an article, several articles that have been written about the role of the prosecutor in the death penalty that I published. And the Kansas did a study. And I'm sorry, I think that statisticians and economists are lovely people, but somewhere they have their head in the clouds. I was talking about the real life work of prosecuting cases. We found that the method of management that they used to make those determinations was statistically flawed. In the district attorney's office, we were all on salary. There were no additional costs. Everything was done within our budget. They came out with a universal figure, some median figure of $1.2 million is what it cost to prosecute one of those cases. That did not come from the state. It only came from the information that was wrongfully provided. And so that was a flawed study and did not reconcile the actual cost of the death penalty. It was blown out of proportion.
You heard the testimony about innocent people being convicted and wrongfully charged. Do you have an opinion as to whether those statistics are accurate?
I don't know the statistics. I do know that there have been innocent people who have been charged with crimes, maybe not involved in criminal cases involving death penalty. I know there's been a lot of discussion about it. The fact is that with today's science, technology, we have been able to solve more crimes with more accuracy and greater positive information that leads us to the culprit in the case,
Okay.
forensically.
And one last thing I wanted to ask you about is a particular case, Richard Grissom.
Richard Grissom
Yes.
was
Could you
convicted.
tell the audience about him and his views on deterrence and the death penalty?
You know, one of the things I must comment on the deterrence issue before I do that is to say that when you look at deterrence as a global issue, I can understand why the economist Dr. Nagin made the comments that he did. It's kind of pie in the sky. You don't really know for sure. But I know for sure that an individual who has murdered, been a mass murderer, who has killed people, will be deterred in the future once the death penalty is administered to that person. In that sense, it is certainly a deterrent. The Richard Grissom case involved the murder of young ladies across the state of Kansas. Grissom, during our investigation, which included the Kansas City Task Force and in Wichita Police Department, during the time that they were talking with many witnesses, there had been discussions reportedly from Richard Grissom that indicated that the bodies would not be found in Missouri because that's where they had a death penalty.
Thank you very much.
You're welcome.
Cross-exam?
Yes. Ms. Folston, I heard you say that there is really no increase in cost. Is that correct?
There was no increase in cost to the prosecution. The cases are based on the facts of each case as opposed to putting a number of how many assets you're going to put into it. If the facts are different in one case, it might not cost as much to try it and prosecute it.
You know David Lloyden, don't you?
Excuse me?
You know David Loudon, L-O-W-D-E-N?
I think you're speaking of David Loudon.
Loudon.
He was the appellate attorney that headed my office appeals division.
And you are aware of the fact that, for example, in the Carr case, the total number of hours placed in the appellate process exceeded 950, and that as of October the 12th of the year 2011, he filed an extension for filing his brief. You know that, don't you?
I was the employer. I was the prosecutor on the Carr case. I saw
My
that.
question was, did you know that?
I'm answering your entire question.
Yes or no? Did you know that?
Did I know?
Yes, about the total number of hours involved and
Well,
the number of requests for extensions.
By the defense?
No, by your office.
Yes, I knew we had requests for extensions,
And-
as did the defense.
And do you also recognize the following statement that's coming from your office? As with every other governmental agency, budgetary constraints are causing a backlog in the system because fewer people are doing more work. The problem is exacerbated when capital cases are thrown in the mix. That came from your office, did it not?
That came from the appellate division with regard to the number of appellate attorneys, not to the office as a whole.
Well, but this...
Not to the office as a whole.
You mentioned a moment ago that this is from your office.
C, yes.
See?
C, yes.
And in fact, your office stated that when capital cases are thrown into the mix, the problem is exacerbated, correct?
In the appellate division, yes.
Whether it's the appellate division or the trial division, the problem in cause is exacerbated by the death penalty. True?
I've answered that question that you asked me.
And the answer is true, correct?
The answer is in the appellate division.
All right. And the appellate division is paid by the same budget that your office is paid.
Certainly.
So it is the same budget.
Different division, same budget. They're all cost-centered.
I understand.
They're all under cost centering, so I had separate budgets for each that I had to rely upon, as opposed to just taking $8 million and putting it on the table.
No further questions.
Okay, we'll continue with the negative case.
I'd like to call Justice James Ardies to the stand, please.
Timekeeper, can you let Mr. Duckers know how much time he starts with, please?
10:13.
Thank you.
I prefer sitting in the center, actually.
Well, I understand that.
You're welcome to come over here, Justice, if you'd like to.
As long as I get to rule on the objections.
Justice Ardies, would you please very briefly for the audience tell them about your educational and professional background?
I was born and raised in Fort Wayne, Indiana, and moved to California. I've lived in California most of my life. I graduated from Fresno State, home of the Bulldogs, currently ranked number 23 nationally. Not doing so well with respect to basketball, however. I graduated from the University of California, Hastings College of the Law, became a deputy district attorney in Fresno, which is in Central California, chief of homicide, then a municipal court judge, presiding judge, superior court judge, presiding judge, appellate court judge, and administrative presiding justice for the 5th District, which covers Central California. I wrote the original monographs on death penalty litigation by which judges in California were trained in death penalty litigation, now part of the Judge's Bench book, and lectured judges in the field of death penalty litigation, sentencing, and decision-making.
So you've had considerable experience in your career in dealing with death penalty cases from a number of different perspectives.
Yes, I prosecuted them, I presided over them as a judge, sentenced them, and in one instance observed the execution of an individual.
Do you have an opinion as to whether the death penalty should be abolished?
Yes, I do.
And what is that opinion?
I believe that the death penalty is a deterrent to the commission of murder, at least premeditated murder, and in that respect is a justifiable punishment given the primary criteria that are utilized in assessing punishment.
And what are the primary criteria used in assessing punishment?
The generally accepted criteria for punishment are deterrence, rehabilitation, retribution, and isolation. Depending upon the magnitude of the crime, each of those is served in some differing respect. By way of example, a crime that, like petty theft, would be primarily concerned with deterrence and rehabilitation. Crimes like rape and robbery and murder are more concerned with retribution and isolation, the increasing magnitude necessitating increased punishment. So when you look at the death penalty, you look at it in those terms.
Okay. And what is your basis for stating that you believe the death penalty is a deterrent to the commission of certain types of murder?
Well, I think one of the issues that comes up with it, first of all, I would say that if we assume that the existence of punishment constitutes a deterrence in general, I think it's unrealistic to say that the death penalty, being the maximum punishment that can be imposed, does not constitute a deterrent. But I think one of the things that comes into play with respect to concepts of the death penalty and deterrence is that it tends to be looked at in terms of murder as a whole. And what you're really looking at with respect to deterrence is, frankly, pre-considered reflection, thinking about things. Most murders in and of themselves, and I would say better than 97% of murders, are not reflective crimes. They're impulsive crimes, they're impetuous. There's not a lot of thought that goes into it until afterwards. By definition, when you get into capital crimes, you're usually dealing with crimes of premeditation, pre-existing reflection, thought, and consideration. In that respect, awareness of punishment does play a role in what a person is doing before they do it as opposed to after doing it. And it's been my experience, certainly anecdotally, I've seen people who've said they've altered their courses of action because of the possibility of the death penalty. But I think you also have to look at the fact that there are a number of studies which have been alluded to that support the conclusion that the existence of the death penalty deters at various levels, smaller numbers of homicides, but I think one has to consider that they're primarily deterring premeditated murder, and because of the small percentage of murders that constitutes, I think it reflects a number consistent with that, whether you say it's 5 out of 1,000 or 18 or whatever it may be. I would expect that it would be a small number and consistent with that. Those studies, I think, demonstrate that there is a deterrent effect to it. And I think there's also an issue with respect to deterrence that has to be considered. When you look at multiple murder, for example, you used an illustration of Osama bin Laden or the Oklahoma bombings. I think certainly when you look at the penalty of, let's say, life without possibility of parole for a capital crime, robbery in the course of a murder, and you look at that for killing 5 people and it's the same penalty, or 10 people, or 1,000 people, or several hundred people, I don't think you can equate them in a way that punishment makes any sense if you're simply going to say the same penalty will be visited on an individual for killing 1 person as opposed to killing 100. I think there's a proportionality that has to be taken into consideration with respect to that. And I think there's also the deterrent effect whenever you sentence people to life or life without possibility of parole. You put them in prison. If that's the only penalty you can impose, you are necessarily giving them the license to commit other crimes, guards, other prisoners, and we've seen that happen. And so your punishment remains the same if that's the worst that you can do. So in that respect, I think that the deterrent effect has an impact. And I also think it has an impact with respect to retribution, which is an appropriate consideration in punishment, magnitude of the crime. And certainly for the most serious crimes, I think we reserve our more serious punishment. In that respect, I think it is a justifiable punishment. So I think it meets the levels of deterrence in the sense of, to the public at large, those that would consider this type of crime, the individuals that would do that, I think it deters. And I think that it's appropriate retribution, and it's certainly, on a very literal sense, isolation.
There's been talk about life without parole as an alternative. First of all, is there any such thing, and is that really a realistic alternative to the death penalty,
Well, I
given
don't
our
think-
political system?
Yeah, I think the answer to that is no. I mean, we do it, but the reality is we've never really followed through with that. And I think that it's unrealistic to believe that that is actually going to happen. And even when we've used life sentences and we tell jurors that, it's not really true. That's not really what happens.
And now I want, because I'm running sort of short on time, I wanted to ask you, you've written a book about a specific case, Clarence Ray Allen.
Yes.
I'd like you to tell the audience about the Clarence Ray Allen case and what happened.
Clarence Ray Allen was involved in a premeditated murder in 1974 in which no body was ever found. I prosecuted that case in 1977. He went to Folsom Prison. In the year for life. There was no death penalty in California. In the year 2000, or excuse me, in 1980, I went out to a small convenience store and there were the bodies of 3 young people, including a young man who had been a witness in the first homicide, another young man grievously wounded. Ultimately, we were able to ascertain that the young man had been murdered because he was a witness in retaliation for his testimony, and the others had simply been in the wrong place at the wrong time. That individual was convicted in 1981 and was executed in 2006.
Who was the individual who had the witness killed?
Clarence Ray Allen.
So from prison, he arranged to have witnesses, not on death row, from prison, he arranged to have witnesses against him and innocent bystanders murdered. Is that
Correct.
accurate? And then when he was prosecuted for that murder, was the death penalty back in place in California?
Yes, it was.
All right. And was he found, and he was found guilty of a capital crime and sentenced to death?
He was, and after 26 years of appeals, it was carried out.
All right. And were you present at the execution?
I was. I think I'm the only judge, certainly in California, that's ever witnessed an execution, at least living judge.
As a judge in California, when a jury returns a guilty verdict, do you have the option of declaring a new trial, in essence overturning that verdict?
Under certain circumstances, yes.
And in a capital case, as I understand it, there is a guilt phase and then a sentencing phase in which the jury in the sentencing phase decides whether or not to impose capital punishment, correct?
Correct.
And does the judge have any say if he thinks the jury made a mistake there?
If a jury returns a death penalty verdict, the judge sits as a 13th juror and has absolute power to set aside that verdict and sentence to life without possibility of parole. If a jury returns a life without possibility of parole sentence, a judge may not set it aside.
Thank you, Justice.
You're welcome.
Thank you very much, Justice. Now, timekeeper, how much time does Mr. Irigonegaray have for cross?
5 minutes and 40 seconds.
Thank you.
Would you please tell me whether or not you would agree with the following statement? There are now over 740 people on death row in California, of whom 340 do not have habeas corpus counsel.
Yes, I would agree with that.
Would you also agree that habeas corpus is the most critical component in the determination of whether a defendant had been wrongly convicted or sentenced to death?
Well, I would not agree that it's the most critical component, but it is certainly a critical component. Yes, sir.
Would you agree that there are many in California that have been waiting for 15 years to have death counsel for habeas corpus appointed?
I'm not sure about the amount of time, but it is an inordinately long period of time. Yes, sir.
Would you agree that the death penalty has been extremely expensive for California?
I think the death penalty is extremely expensive, period.
Would you agree that the study performed by Judge Alarcon and Ms. Paula Mitchell from Loyola concluded that since 1978, the system in California had cost taxpayers over $4 billion more than if life imprisonment would have been the only possibility?
Well, I'm familiar with the study. No, I don't agree with that. I think that there are a number of assumptions that are made with respect to that are really, that really fail to take into account the reasons for the costs.
Have you performed studies yourself to challenge the report prepared by Professor Paula Mitchell of Loyola and Judge Alarcón?
No.
You would
But
agree.
I can tell you that I have been heavily involved on behalf of the Supreme Court of California and the appellate courts in California with respect to issues affecting the implementation of the death penalty, appointment of counsel, and habeas issues. So I'm familiar with those issues and why it occurs. So I would simply say that to relate them is not necessarily consistent with the issues in the death penalty.
You've indicated that you believe deterrence is a product of the death penalty.
I believe that the death penalty at levels with respect to premeditation deters, yes, sir. And I believe that there's a moral consequence with respect to failing to carry that out, and the moral consequence is that if you do not impose the death penalty, I believe that innocent people will die. It may be a small number, but it will be a number of people nonetheless. And I think failing to carry it out creates a moral conundrum in the sense that as a result of that, people will die that wouldn't have otherwise have died. And I think that is a consequence that must be considered.
Are you considered with the morality of executing innocent people?
Of course.
So if we know, as the studies indicate, that errors occur and they occur with significant regularity, should we not review a sentencing scheme that includes the potential of killing innocent people when in fact there is an alternative, life imprisonment without parole, that would remove that moral issue?
Well, as a criminal defense attorney, you are well aware that there's a distinction between innocence in the fact of factual innocence and being found not guilty, and the fact that somebody may have an error with respect to their trial does not bear necessarily any relationship to whether they are in fact innocent.
But there are those cases in which innocent people are also convicted,
Yes, sir.
vis-a-vis
Yes, sir.
coerced confessions.
Yes, sir. There are. And the same thing occurs with respect to every level of crime that we have, which means it occurs with respect to people who receive life without possibility of parole and who receive much less scrutiny than those cases involving the death penalty, which are heavily scrutinized and receive the most attention of any type of crime.
But if we sentence someone to life in prison without parole, we at least have the safety valve of being able to check whether or not people like you, people like me, have committed an error which would otherwise have put someone to death, correct?
No system is perfect.
And since no system is perfect, and since the death penalty attempts to seek a perfect solution, don't you think it's about time that as a society we said, we are simply imperfect in our system of justice to both timely and effectively deal with the death penalty?
And my answer would be that the moral conundrum that you create by that is that because you say a system is not necessarily perfect, you save a guilty life and you subject innocent lives to being lost.
When you say you subject innocent lives to being lost, what about the innocent person being put to death? And isn't then the moral answer to stop both?
My turn. He's out of time.
But I was doing so well.
You were, which is precisely why you're out of time.
Justice, thank you very much. I am going to ask the students to pick up, if you have an index card with a question on it for affirmative or negative, please hold it up. I'm going to ask our two advocates if they would come up to discuss something with me very briefly.
Are our mics off?
Not off. I think I told you that Ted got the closing statement, but I actually have in my notes
first and Pedro went second
That's
on
what I'm
closing.
saying.
Yeah,
That's what I'm
that's how we did it last time.
Is that okay?
Yes.
Okay.
Yeah.
Okay.
He has the
I thought I
burden of
told
proof.
you something different. Yeah. Okay, we've collected those questions. I will pose those questions in just a couple minutes, but now we will move to the closing statements. We'll start with Mr. Duckers.
Thank you, Director Lacey. I'm reminded of a quote from Mark Twain, famously attributed to the 19th century British Prime Minister Benjamin Disraeli, in which he said, "There are three kinds of lies: lies, damn lies, and statistics." I'm reminded of that because what you've heard here tonight is, to some extent, a statistical battle between scores of peer-reviewed academics who have concluded over the years that the death penalty is a deterrent, and one study from the expert for the proposition in which he says, "I don't know whether it's a deterrent or not, and I haven't done the work to find out about it," which is what you would have thought he should do. But I'm also reminded, because I have this discussion with a friend of mine who's a professor at the University of Texas. He's a fine Kansas graduate, and every discussion I have with him, he says, "Well, there's an academic study that supports the proposition that the moon is made of Swiss cheese." And I say to him, "Frankie, I've been doing this for 28 years. Let me tell you something. I can walk onto any college campus in this country, and if my pockets are deep enough, I can buy any opinion I want on any side of any issue. And I can do it in an unassailable fashion with someone whose opinion you're not going to be able to take apart unless you yourself are an expert in that field." So when you get into these competing battles of academic studies, I think that what you really need to do is to step back and apply reason and logic and common sense and listen to the people who are not in the ivory tower, but the people who have been down in the trenches and actually dealt with administering the death penalty to people who richly deserve it. This case has shown you, I believe, beyond peradventure of a doubt, that the death penalty does serve as a deterrent. But the fact of the matter is that the burden of proof is on the advocates for this proposition. We have the death penalty. They want to do away with it. And so they have to prove to you that it is not a deterrent and there's no reason to have it. Have they done that in this trial this evening? No, they have not. They have not shown you that the death penalty does not deter crime. And you in your own minds know that it does. I mean, just take, for example, the 20-year campaign that has been going on against drunk driving. We've increased penalties. What's happened? The incidence of drunk driving has gone down. We increase penalties for other wrongs, and the incidence of those wrongs go down. We all know that increasing the punishment for a crime deters the crime, yet for some reason when it comes to the death penalty, we're asked to suspend logic and reason and think that that sort of deterrent effect no longer applies. So when you all retire to the jury room tonight to deliberate, I want you to imagine that sitting on the desk in front of you is the legislation to abolish the death penalty, and in your hand is a pen. Now, if you knew that signing that bill that might save one guilty life would be a death sentence for 100 innocent lives, would you sign it? If you knew that it was just 10 innocent lives that you were condemning to death by signing the bill to abolish the death penalty, would you sign it? If it was just one person, would you sign it? Even if you did not know for a fact, but felt there was a substantial or even realistic probability that by signing that legislation, an innocent person would die, could you sign that bill? Could you live with the blood of the innocents on your hands? Well, I know I couldn't, and I don't think any of you could either. Thank you.
Thank you. Mr. Irigonegaray, you have 5 minutes.
Mr. Ducker, Mr. Lacey, I suggest a different paradigm. You are a single mother. You're African American. You have 3 children. One of them has been accused of murder, and the prosecution wants to put your son to death, but you don't have the wealth of a Mr. Ducker. You don't have the wealth of the wealthy. You're barely getting by on minimum wage, and your son is being represented by a public defender that is overwhelmed with cases. And you know mistakes are made. You know prosecutors conceal evidence. You know lawyers, like me, make mistakes. Are you going to want the prosecution to have the power to send your child to a gurney to be killed in the name of justice? There has been an attack here on deterrence. I suggest to you that's only one issue. One of many. The most important to me is the innocence of the client. The fact that we are simply imperfect in our judicial system to provide society with the perfect solution. We have seen what happens when people try to come up with the perfect solution. We are incapable of delivering the perfect solution. I have been in the trenches. I have represented people accused of murder. I have prosecuted people accused of murder. I know personally what it is like to have a client sitting next to me facing the death penalty. And I know my imperfections. And I assure you, you do not want your children sitting in a prosecution wherein you're going to have to rely on an imperfect system to determine whether or not they're going to be put to death. This doesn't mean we're soft on crime. This doesn't mean we don't hurt for those members of our society that are brutally injured by murder, rape, and a variety of other crimes. But we have to be more intelligent as to how we deal with these issues. First of all, financially, we can't afford it. Our state judicial system is over $8.2 million in the red this year. Who's going to pay for the public defenders? What is the answer? We'll rush through to judgment. Rush through to judgment? What about the innocent? The savings that we can generate by abolishing the death penalty and putting criminals in prison for life without parole. And I disagree with the honorable judge. Kansas judges do not set those type of people free. Maybe in California, but not here. Not here, Judge. We respect the law. And what I suggest to you is that this is not a liberal issue, as was attempted to be portrayed by my opponent, suggesting that somehow the opinions were bought. You think Dr. Nagin can be purchased? The integrity of the National Academy of Science? The fact is, there is no evidence to suggest deterrence exists. The fact is, mistakes are made. The fact is that hundreds of people have been exonerated. The fact is that we are imperfect as a society to exercise the perfect solution. And as you're in the jury room tonight, I want you to think, when you have that pen, of your child sitting in that chair next to me, and a prosecution intending to kill him or she. Don't let that mistake happen to your child. Don't let that mistake happen to anyone's child. We must abolish the death penalty. We simply don't have the ability to carry it out fairly, justly, or morally. Thank you.
Thank you, sir. Before I get the cards somebody's got some cards for me. Why don't we thank our two advocates and the witnesses for a wonderful, wonderful debate tonight.
Outstanding as always. Outstanding.
Thanks. Eric, if you want to bring up the questions, we'll take about 10 minutes to try to
Thank you, sir.
get through a couple questions.
Sorry about that.
These are for the affirmative.
Thank you, sir.
You guys were great.
Thank you very much.
I'd much rather have that row, by the way.
Okay. Okay, I'm going to try to get through as many of these as I can. We have time for 2 or 3 at least. And the way I would like to do this is I will pose the question to the affirmative or negative case, and then, you know, Eric, I'm also going to grab you back, and if you would take these cordless mics and take a cordless mic, and you, if either of the advocates want your experts, one of your experts to address any of these questions, you can appoint them or you can do them yourselves, and Eric will take the microphone and make sure that they're mic'd. This first question, I believe, is for the affirmative. Relative to the death penalty, what is the deterrent of life in prison without parole, and is it less effective? Eric?
The answer to that question is that we don't know, and we don't know because we don't have the data to be able to answer the question. And the implication of that is that we will, as long as we do not make the investment in the data infrastructure to answer questions like this, we are going to continue to build and make criminal justice policy based on people's opinions. I would point out to you is, think about in a different domain of your life, medical care. How would you like it if your doctors administered treatments based simply on their opinion about what they thought was effective without the basis of the kind of good scientific research that the National Institutes of Health provide us for us? We remain in an era, like medicine was in the early 20th century, where doctors did things simply based on their opinions. And so, unfortunately, I can't answer that question about the deterrent effect of life without parole because we don't even have the data to begin to study the question.
Okay, thank you. Question for the negative. What type?
Don't we go back and forth? Each get to respond?
Yes, yeah, that is correct. Thank you, Mr. Duckers.
With all due respect to Professor Nagin, it is not a matter of opinion. I mean, there have been 27 academic studies done just since 2000 that determine there is a deterrent effect. He's a very impressive scholar. Recognize that there are equally impressive and credentialed scholars who have published peer-reviewed papers, and his paper is not in any peer-reviewed journal, that state the death penalty has a deterrent effect, that there is sufficient data to draw that conclusion. I respect the professor's opinion that that data is not good enough, but understand no one that he has criticized or critiqued has changed their opinion, and they are respected academic minds who considered the evidence that we had and reached an absolute conclusion as to the number of deaths that have been deterred. May I respond to that, please?
Very briefly, wait for the microphone. And I'm going to, after this time, I'm going to give each side just one opportunity to
Mr. Doherty
respond.
has repeatedly stated that there's only studies showing there's a deterrent effect. The reason that the National Academy of Sciences asked us to do this study is because there are comparable numbers of studies that reached the opposite conclusion. And this review that we did was not based on my opinion. It was based on the opinion, on the assessment of 8 other distinguished scholars and an assessment of the evidence. And we explained why we thought this evidence was not informative. And none of the people whose work we criticized have yet to respond why our assessments were wrong.
Okay, thank you. Now, a question for the negative case. What type or degree of murder must happen for a person to be sentenced to death, or what exact crimes?
Which one of you wants to handle that?
In the state of Kansas, we have 7 special circumstances: the killing of a law enforcement officer, the commission of 1 or more crimes involving the death of individuals, the killing of a guard inside of a penitentiary, the sexual assault of a child, the kidnapping of a child and their murder, and the cruel, atrocious, heinous crimes that come under only the 7 qualifications that the law provides. Because they are there, they can still be charged with a capital murder. But based upon the opinion as to the nature of the case, the individual facts of each case, you can't make a cookie cutter case. You can only look at it and make the determination if you will ask for the death penalty. And in many instances, the cases are tried, maybe capital cases, but the death penalty is not asked for by the state.
Would you like to respond, sir?
Take a look at Kansas statutes annotated 213439. That's the specific statute that sets forth the parameters for the death penalty in Kansas. And it will provide you with a better understanding of precisely how the death penalty is applied in our state.
Okay, we are out of time. I like to try to keep the same number of questions for each side, and we're out of time, so I'm going to conclude that at this point. But again, I want us all to join and thank our advocates and our experts tonight. If you like this format, if you want to see other issues discussed in this format, send us emails. We look for ways to count audience, excitement, and influence. So let us know if you liked it. Thank you all for coming out. Don't forget about Constitution Day next Tuesday night, the Fellows Reunion Thursday and Friday, and make sure you check out who is going to be receiving the 10th Anniversary Dole Leadership Prize tomorrow. Thank you all for coming out tonight.
Thank you.
And I'd like to be before your court.
Yeah, well, I like this. Yeah, we're good.